McClelland, welcome to Capitol Hill.
Thanks for having me.
When the High Court decision on Malaysia came down, the Prime Minister suggested the Chief Justice had given a different decision when he was on the federal court, and she also said an opportunity had been missed to send a message to people smugglers. Now, when you were in opposition, you gave a speech defending the courts and effectively saying the Attorney-General should stand up for the institution of the courts. Should you stand up for the courts now?
Yes, the Attorney-General's role is to defend the court against any personal attacks. Judgments and the reasoning contained in judgments is always fair game, but the Prime Minister intended no criticism of the individuals or the court itself, rather questioning the reasoning.
But she did single out the High Court Chief Justice, Robert French, and compared the decision now with one he'd taken earlier.
She compared the difference in his reasoning as she perceived it in the recent decision to an earlier decision. But again, she at no stage was questioning his motives or his decency or his competence. And it's certainly an important role of the Attorney-General to ensure that the public has confidence in all courts, quite frankly, all federal courts, but most specifically the High Court. And I can confirm unreservedly that the government has full confidence, obviously, in the High Court and each and every judge of the High Court. It goes without saying. The criticism of the reasoning contained in judgments is, however, the subject, legitimately the subject of discussion. As
a result of that High Court decision, the option the government's left with, if you want to choose to restart offshore processing of asylum seekers, is to change Section 198A of the Migration Act. Can that be done, on your advice, in a way that will stand up in the courts, given the High Court decision?
Yes, we believe so. We believe that an amendment is appropriate. Obviously, the Cabinet and caucus have to consider these issues, but yes, we believe that an amendment is desirable to put offshore processing beyond doubt. We think that should be done. And
an amendment that in all likelihood would stand up in the courts if challenged?
Yes, we believe so. We believe an amendment can be crafted that essentially gives, if you like, a stronger discretion to the Minister to determine the appropriate destination for offshore processing. We think that can be crafted.
And do you think, given that the High Court decision, the High Court seemed to say that under the current law that any protections that are offered have to be confirmed by domestic law in the third country or by signing the Refugee Convention, effectively you just sidestep that and craft an amendment which gets around that?
Well, look, essentially the court said either they have to be a party to the Refugee Convention or have domestic law in place to reflect the provisions of the convention, and probably to have those laws and principles administered in practice. And the court's reasoning was that the current Minister for Immigration had to have regard to those factors before making a decision. And so what the amendment would do would define or restrict or more precisely define the factors that the Parliament wanted the Minister to have regard to. That is narrower than those construed by the court. So
effectively the Minister wouldn't have to be certain that there were the rights and protections legally in the third country?
Well, again, it's a question as to how it's applied, but that certainly could be done to narrow the range of factors that the Minister had to consider before making his decision. So that's if there was an amendment to be made, it's likely to be made in that form.
Can you craft an amendment too that will cover the offshore processing of unaccompanied minors, or is that actually a more difficult issue given the court decision?
Well, that issue could also be addressed, but but clearly when it comes to unaccompanied minors, there are public policy considerations that the government would have to weigh up very carefully. It is a very difficult issue. There's no question about that. I mean, obviously all Australians would like to see minors, and we have international obligations to ensure that minors are treated properly and humanely. Equally, we don't want to see a situation where the people smugglers take advantage of any weakness in the laws to simply stack these these rickety, unseaworthy boats with young people.
We've been talking about decisions which could possibly get through the courts. Is there a chance, though, that a decision to reinstate offshore processing might not get through your own party because the left at least wants onshore processing only?
It'd be wrong of me to try and preempt the debate. It's certainly going to be an issue, and I think the public would expect there'll be an issue of debate, and there'll be arguments of substance put both ways. So I don't want to preempt that, but clearly there will be intense discussion and indeed debate about the matter.
As you mentioned, there'll be a detailed discussion and debate about this issue. Parliament starts again next week. There's also going to be debate and discussion about the carbon tax and the mining tax. There's already rancour over the issue of pairing of votes. You've given a speech where you say you're worried about the lack of civility in the Parliament and that has the potential to damage the credibility of the institution. That would apply to both sides of the Parliament, wouldn't it? It's been particularly rancorous over the last year or so.
In my 15 years in Parliament, I have not seen it as vindictive. I don't think it is constructive. I don't think it is an attractive image for the public. I think the public wants to see more civility in the Parliament. And I think we all have an obligation to lift our standards.
And is it incumbent on the Labor Party as the party of government to take the lead on this, to make sure you answer the questions you're asked in Parliament, to make sure you don't include personal attacks in those answers?
I think it's incumbent on both sides, but certainly people in positions of leadership unquestionably have additional responsibilities. I think that's a fair point to make.
It's been 10 years since the September 11 attacks in the United States. Do Australians still face significant terrorist threats from at home and abroad?
Regrettably, that is the case and will remain the case in the foreseeable future. Unfortunately, and it should be stressed that there is a small element in our community that would harm their fellow citizens for extremist motives, and regrettably that is the reality and will remain so for, unfortunately, the foreseeable future.
When you came to government, you inherited a much beefed up police and security institutions. ASIO, for example, is being built a new building that's one of the biggest in Canberra. Do you think the security institutions have grown too much in the time since September 11?
No, I think they've required the resources. They are substantial resources that are being devoted to domestic security. There is no question about that. But the greatest physical threat to an Australian today is not from an invasion from a foreign country. It's from the potential of a terrorist attack. So I think these resources are justified. I think the agencies are performing well. They are individually of a high calibre, but more importantly, working together, I think, very cooperatively, and I think in that sense are giving us a good return.
Robert McClellan, thank you very much for your time.
That's my pleasure.